The Constitution did not want you to be a graduate. I think that was inserted in 2008.
Yeah.
By Musharraf was then the president.
2002.
2002. So, but it is not one of the prescribed conditionalities either of 62 or 63.
It was perhaps introduced under Clause P, subclause P of subclause 1 of 63. 63(1)P, which permits prescribing additional disqualifications through an act of parliament.
Read it again. P1P kya hai?
He is for the time being disqualified from being elected or chosen as a member of the Majlis-e-Shura, Parliament or of a provincial assembly under any law for the time being in force.
Now, here the word time being has been used twice.
Yeah.
It could have said he is disqualified for being elected. So time being.
Yes.
And it's been used, the word time being has been used twice in this thing. So it assumes it's not a permanent disqualification. I don't know.
That's what the first usage of for the time being actually indicates, what my Lord has just observed, that perhaps it is a time-bound disqualification which can be introduced through a statute.
Okay. Now, with regard to the disqualification of, did the law for degrees, the law did not provide a time period disqualification. So the Supreme Court, in the case of Samiullah Baloch, held that since no disqualification period has been prescribed, it will be forever.
So long as the declaration is in the field, the disqualification stays.
And the two be resolved now. If the judgment of the Supreme Court also stands and the law also stands, that till the law came into effect, that may have been the position. But since the law has now occupied the field of legislation and prescribed a particular period of time, unless we hear a challenge to the law, which there is no challenge to the law, then why should we disregard the law? That's one way of looking at it. And we don't need to touch the judgment at all, because at that time, this aspect of the matter had not been legislated upon either in the Constitution or by law. So then the courts kind of filled in the vacuum and said that it should be lifetime because there is no period of disqualification. So Samiullah Baloch judgment stays intact, but the law has come in place and it is in the nature of a non-obstante clause. That's one reading of it. What do you have to say to that?
So the question would be, can the sub-constitutional legislation control the Constitution?
So that is one, and then the second would be, can there be legislative overruling of a judgment without first removing the basis on which the judgment came out? So,
can we go to the judgment now of the Supreme Court?
My Lord,
relevant provisions, whatever you think are relevant for our reading.
Paragraphs, my Lord.
Paragraph 35 है.
G35 and
444 page पे.
G. So this is PLD 2018 Supreme Court 405.
ये चार जजमेंट जो
one thing is very important.
उनका रेफरेंस है पहले इसके अंदर ना, चार जजमेंट हैं, उसके साथ फिर समीउल्लाह आई, एक इम्तियाज अहमद का केस है, एक अब्दुल गफूर है, एक मोहम्मद खान है और एक अलादीनो भाइयों है.
Aladino Bhayo, first Aladino Bhayo, and then the review which came out later in 2020, and the court took a somewhat different view.
Mr. Attorney General, to nullify Samiullah Baloch, the amendment would have been in the Constitution.
My Lord, and that's why I
mean, if you're looking at the basis of the judgment, the basis of the judgment emanates from the Constitution. So unless the Constitution were to be amended, Samiullah Baloch could not be undone.
So, because Samiullah Baloch is interpreting a constitutional provision, and Samiullah Baloch basically holds that the declaration which is referred to in 62(1)(f) has to remain in field till such time, till such time the declaration in the field, the disqualification stands. Then what my Lord has observed carries.
There is no time limit provided under Article 62.
So there are no time limits as far as my Lord the Chief Justice had just gone through, took us through clauses A through G. Now as far as D, E, F are concerned, they are all without any timeline. Now, the question before your Lordship, and it was also argued in Samiullah Baloch. In fact, all the councils before Samiullah Baloch.
If we consider that through Samiullah Baloch the Constitution has been amended, then the constitutional amendment is required, as per my understanding.
My Lord,
it is interpretation.
My Lord, with respect, Samiullah Baloch also read something into the Constitution which was not provided. And
like, what did they read into the?
My Lord, while comparing now, while examining 62(1)(f), the court held that so long as the declaration is in the field, this disqualification stands. While at the same time, when they were examining 63(1)(h), which is under 63 and relates to moral turpitude, which includes dishonesty, and there is a 5-year time limit, the court took a different view while examining both, and it said that because there is a personal price that a person has prepared by going to prison, so therefore 5 years is good enough. But what the court did not, or with respect, overlook was that in both cases the declarations are there. Now in 63(1)(h), there is a conviction which stands. It's only that
it's really a question of interpretation, because what's very interesting, speaking for myself, if you look at 63 G, H and I, I mean, most of the heinous crimes, especially against the integrity and sovereignty of the country, and that person can be allowed to contest election. Where there are punishments, he goes through punishments and comes out and contests election. What is a bit odd is that a civil declaration, which is just for some misdemeanor, like misconduct, which doesn't even carry a criminal punishment.
Absolutely.
That carries an absolute bar for the rest of the life. That seems to be a bit odd, because if you commit murder, you commit treason, you commit whatever, you can come back and contest election. But if you just forget to write something in the form, you would be out forever. So how does one reconcile? So it's a matter of interpretation.
Yes, so that is what my respectful submission would be, because in both, in G, H and also in I, there is an adverse finding against the person, a declaration by a court of law against that person. In those proceedings, those declarations of course subsist. He serves the time or whatever punishment provided by law, and then he can come back in after 5 years. Now here, while looking at 62(1)(f), where there is this, the standard of proof is lower compared to those criminal proceedings under 63(1)(h), which is beyond any shadow of doubt, and that declaration has still come out beyond any shadow of doubt. And here is preponderance of evidence or somewhere between the two, and here the person is out forever.
But before we go into that, could you just explain to us how can any court, a civil court, grant declaration which is in the negative? I mean, how can a court grant a declaration that you're not sagacious? That cannot happen. So how does that work? I mean, I've been always perplexed about this. We can't get a negative declaration from any court. Can a court say that you're not sagacious? Why would that happen? Because no civil proceedings could lead to a negative declaration. It's always positive. So I don't understand how a court will ever give such a declaration. So then most of the courts which have given this declaration are the constitutional courts. So you have
that's another question.
And in those cases, is the declaration absolutely clear? I mean, does it say that you're not sagacious, or then we infer from the judgment that because you presented a fake degree, as a consequence we understand that you are not a mean? I mean, let me just go to the language of 62(1)(f) to understand what do we mean by declaration.
Declaration, and also what is a court of law, because, and I say this, and my Lord has just observed, in Ishaq Akwani's case in 2015, a 7-member bench actually framed these 4 questions. They left them unanswered for some other case in future, and those questions were that what would be that court which is to give this sort of declaration? What would be the
happened
procedure?
then in that case?
They left it open, sir. These questions were not answered by a 7-member bench. So which court would it be? What procedure would it follow? What would be the standard of proof? And who will have the locus standi? Now these are the questions which are very, very relevant for the purposes of for this declaration by a court of law. And then also whether the courts exercising, let's say, constitutional jurisdiction, who cannot record evidence, where witnesses cannot be cross-examined, a person against whom an allegation has been brought cannot really defend himself as he is able to in a trial. Would the declaration coming from constitutional court suffice for 62(1)?
Attorney General, the question which has been there for a while now is, first of all, can there be a civil court granting a negative declaration, number one? And number two, the question is that in constitutional proceedings, where there is no evidence being taken, the court has arrived at a decision that a fake degree has been, for example, I don't know what the other cases are, fake degree has been presented by this person, does not necessarily mean that the court is moving further and saying that you are now non-sagacious or whatever. It's simply saying in this particular matter a false degree was presented. But I don't know of any judgment where they've actually gone ahead and said then as a consequence you're a fraud. So I don't know, so is there a declaration actually coming out of the Constitutional Court also? And can they, without taking any evidence, give such a declaration about a person?
My respectful submission is, my lord, that a constitutional court, now mindful that this 7-member bench left these questions open, but then there are two judgments, one in PLD 2015 Supreme Court 265, which is Panama 1, Justice Ijaz Afzal Khan, speaking for majority, said that a court of law for the purposes of 62(1)(f) would be a court which can actually record evidence, which is a plenary court of original, revisional, appellate jurisdiction in civil and criminal proceedings. But
without recording evidence, declaration can be given?
Cannot be given. And then the same...
But even a negative declaration cannot be given, even if you record evidence. Right, I don't understand this. So
and then in Aladino Bhayo, the second Aladino Bhayo, the review Aladino Bhayo, they revisited the original judgment which was given in 2013, whereunder it was held that once a declaration at 62(1)(f) is given, it does not go away with the flux of time.
Declaration में तो यही है ना कि person may not file his own case for declaring him Amin.
Yeah.
Somebody has to challenge his character.
That's right.
Then in that case, the declaration will come whether he is Amin, sagacious, righteous or not.
Yeah.
So ये declaration होगा ना, खुद तो जाके नहीं मांग सकता declaration.
दूसरा negative as per
somebody will come challenging.
सिर्फ paternity पे हो सकता है शायद, एक exception है 42 में, there is no other exception.
Section 42 में तो legal character कोई deny करता है तो suit file होता है ना. If somebody is denying his legal character, then he can file the suit under section 42 of the Excessive Act.
और अगर आप कॉन्स्टिट्यूशन कोर्ट्स के केसेस भी ले लेना तो फॉर एग्जांपल somebody has not, for example election tribunal says that the nomination form में फलां चीज नहीं है तो मिस डिक्लेरेशन इन्होंने की है, चलो ये बात तो हो गई, इन्होंने मिस डिक्लेरेशन की. अब इसका क्या मतलब, फिर हम खुद जोड़ते हैं, हम कहते हैं कि क्योंकि मिस डिक्लेरेशन की है इसलिए फिर आप अमीन नहीं है, इसलिए 62(1)(f) लग. बट द कोर्ट हैज नॉट सेड इट, द कोर्ट इज नॉट डिक्लेयरिंग दैट यू आर non-sagacious or not Amin, but the court is simply saying you have filed there's been a misdeclaration in the form. So उस पर जरा elaborate करें, how do we actually get, where is the declaration, actual declaration from the court?
तो उसमें कहीं पर वो correction के भी provision है अब जो nomination papers हैं.
और ये सो मोटो डिक्लेरेशन है या कोई केस फाइल होने के बाद है ये डिक्लेरेशन?
Now this is again very interesting because in some judgments in Sher Alam's case, for example, the court says that a writ for quo warranto can be filed, and that obviously comes in constitutional jurisdiction. And in fact, this court can take suo motu notice under 184(3) and gives
quo warranto. ना वो तो Article 199 में it is totally different.
बिल्कुल.
The person has to show under what authority of law he is enjoying the office.
That's right, sir.
But वो तो ऑफिस में जाने के बाद है, not prior to.
जी ऑफिस में जाने के बाद होगा, but as far as that declaration is concerned, question is, can that declaration be given in those proceedings, or for that somebody has to go to civil court or some court which has the original jurisdiction to try and receive evidence, allow the person against whom an allegation has been brought to cross-examine.
एक चीज जरा देखिए, come back to Article 62. Read G.
He has not, after the establishment of Pakistan, worked against the integrity of the country or opposed the ideology of Pakistan.
Yes. Now, if we read 62(1)(g) on its own with the judgment of Samiullah case, the ban is lifetime ban.
But
if we read them together.
But
Now read 63(1)(g).
जी
It's the same language ideology of Pakistan.
जी for
And
propagating
here it prescribes a ban for 5 years.
जी or the sovereignty, integrity or security of Pakistan.
No, it's the same 62(1)(g and 63(1)(g are more or less similarly worded.
That's right.
It is working against integrity or opposed to the ideology of Pakistan.
That's right, sir.
Now, if we apply Samiullah Baloch to 62(1)(g, it is lifetime ban. And if we apply 63(1)(g, it is 5-year ban. Unless you say 62(1)(g, Samiullah Baloch is not attracted to 62(1)(g. That could be one argument. So
it's interesting what my lord has observed, because if a person is dishonest और उसके खिलाफ मुकदमा दर्ज हो जाए और उसको सजा हो जाए तो फिर 2 साल काटने के बाद 5 साल बाद वापस आ जाएगा. मुकदमा ना हो और पता नहीं क्या हो और एक declaration आ जाए तो then he's gone.
if he has been convicted and goes to jail, so his sins are expiated, right? And he's okay.
Yeah.
Now, if he is, for instance, acquitted or is not even prosecuted, then he is lifetime banned. So I find it difficult that a court of law which has convicted a person, meaning your guilt was established 100%, you are banned for only 5 years. And if your guilt has not been established, because every criminal case has 2 components, conviction and sentence.
That's right.
You can be convicted and you can be sent on parole, or you can be convicted till the rising of the court, or whatever it is, or maybe not. Say for good conduct, we don't convict you this time, we don't sentence you this time, we just convict you.
That's right.
So that will be a lifetime ban, and the person will say, can you please send me to jail so I can contest elections again after 5 years?
Yeah,
I would rather
the
go
rising of the court so I can just go back after 5 years.
So see, certain things are very clear. You are a citizen of Pakistan. I mean, I find okay that it's pretty clear. There may be some gray areas where you may be holding 2-3 nationalities or whatever the case is, or you may have given up or whatever. But generally, age is a determinative factor. It's clear. And then we come to D, E, F, and G, which are vague, and they're overlapping as well, because it says is of good character. Now, can any human being possibly say this on oath if he's truthful? If he's truthful.
So it appears that as far as D, E, and G is concerned, there's no third-party declaration. You know, who's actually saying that he doesn't have adequate knowledge of Islam? Who's saying that he's said anything against the integrity of the country? So there's no third party, right? So how does the disqualification work? On that election, and then it forgets about it, and then the next election he can contest? I mean, we found out that he doesn't have adequate knowledge of Islam 20 years ago, and he missed the elections that time. Then he's now become a saint, perhaps.
Alim.
An alim. And then what happens?
Hafiz, alim.
So एक तो वो समझ नहीं आ रही, लेकिन फर्क सिर्फ ये है कि F में तो ये है कि एक declaration खड़ी हुई है third party की, तो जब तक वो खड़ी हुई है वो चलता रहेगा. That's what Samiullah Baloch is saying. Samiullah Baloch actually turns on the declaration.
वो हुआ ये कि actually 18th amendment में ये जो declaration by court of law लाने का purpose तो ये था कि वो returning officers जो है ना वो डिटरमिन ना करते रहे या इस किस्म का एलिगेशन कोई और रैंडमली ना आकर लगा दे, और ताकि ये जो डी, ई और जी के अंदर जो हो सकता है वो एफ में ना हो.
आपके मुताबिक
उल्टा हो गया.
How does D, E and G play out actually? I want to ask this question. आज से 10 साल पहले किसी ने इंटेग्रिटी ऑफ पाकिस्तान के बारे में कोई बात स्पीच कर दी, बस खत्म हो गई बात. अब वो इलेक्शन नहीं लड़ सकता.
ये देखिए कुछ लोग होते हैं तो
उन्होंने 5 years कर दिए,
वो कहते हैं यस आई हैव सीन द लाइट. अब इस्लाम में भी तौबा की गुंजाइश आखिर मिनट तक है. वो कह सकता है जी मुझे, जैसे माय लॉर्ड ने ऑब्जर्व किया कि मुझे इस्लाम के बारे में नहीं पता था, अब मैंने सारे अब लाइफ टाइम बैन उसको कर दिया कि वो फिर शायद हाफिज बन गया हो सकता है, आलिम बन गया हो सकता है, आप और बेहतर और हम सबसे बेहतर कुरान शरीफ समझने लगा हो, और वो लाइफ टाइम बैन में आ गया क्योंकि उसको 20 साल पहले या 10 साल पहले या 5 साल पहले इन चीज़ों के मुतालिक इल्म नहीं था.
समीउल्लाह बलूच जो है इट एक्ट्स एज अ गलिटीन. वो कहते हैं कि जब आखिरी अपील में जब आप आएंगे तो बस उसके डिसीजन से पहले तो अगर आप रिपेंटेंस कर लें तो हो सकता है, वरना वंस that happens, then there is no
repentance का मौका
repentance.
कहाँ छोड़ा?
نہیں چھوڑا 184(3) میں تو ویسے ہی نہیں ہوتا, بٹ ادروائز بھی نہیں.
ریپینٹنس کہاں لکھا ہوا ہے
صاحب سنیں ذرا, جی صاحب
سمیع اللہ بلوچ
دیکھیں اس میں اصل بات یہ ہے کہ ڈفرنس ہم نے معلوم کرنا ہوگا 62 اور 63A میں. واٹ از دا ڈفرنس بٹوین the two? As far as I'm concerned, 62 is not giving power to decide against a person. دیکھیں اس میں تو سمپل یہ اٹ از ڈیپینڈنٹ اپون 63 میں جو کاروائی کریں گے وہ دکھائیں گے, 62 میں وہ کہیں گے یو آر ناٹ کوالیفائڈ, ویئر ایز ڈسکوالیفیکیشن از ان 63. اگر کوئی شخص سپوز کوئی کام کرتا ہے, کوئی غلط کام کرتا ہے, تو اگر آپ جی اور ایچ کو پڑھ لیں, جی اور ایچ وہ ڈٹرمائن کرتے ہیں کہ کورٹ آف لا سے جب اس کو کوئی ڈکلریشن ہو, یہ اس ڈکلریشن کی بات ہو رہی ہے, آئی تھنک سو. جی اس پہ بات کریں کہ یہ 60